Okay, in this video I want to take a look at the recent striking down, very recent case in the High Court of the sectoral employment orders. There was 3 sectoral employment orders, one in the construction industry, one in the electrical industry, and the other one was in, mechanical engineering. But the sectoral employment orders arose from the Industrial Relations Amendment Act 2015, and it gave the Minister, once certain steps had been followed and certain safeguards had been followed, the authority and the power to bring in by statutory instrument certain orders which governed the relationship between employer and employee in certain sectors. This particular one was to do with electrical contractors or electricians, electrical workers, and the National Electrical Contractors of Ireland brought a challenge, a judicial review, to the High Court. And they were basically saying or asking the High Court to find that the sectoral employment order was invalid and unconstitutional. And as I say, the order would be brought in by the Labour Court, not by the Labour Court, by the Minister and Minister for Business, Enterprise and Innovation. And that would be following a report or a recommendation or a report from the Labour Court, which was one of the steps that needed to be followed. The National Electrician or Electrical Contractors of Ireland brought the claim, as I say, or the judicial review to the High Court, and the judge found that the Minister made a mistake or erred in finding that the requirements of the Industrial Relations Amendment Act 2015 were complied with, and therefore the Minister was not entitled to make the particular order, the employment sectoral order, that she signed. Now, the 2 principal reasons for it was that, number 1, the report from the Labour Court failed to record the conclusions of the Labour Court on important matters, and 2, the report from the Labour Court failed to set out a fair and accurate summary of the submissions made by interested parties who were against the making of a sectoral employment order. Clearly, the making of a sectoral employment order has massive implications for the businesses involved in that industry, because they are being told that they have to pay particular minimum rates of pay, they have to make provision for pensions, and so on and so forth. So there's public policy issues at stake, because you're striking a balance between, on the one hand, looking after employees, looking after workers, and on the other hand, not bringing about anti-competitive, anti-fair trade legislation. The court in this case, Judge Simons, held that the order was unsafe, the Minister was incorrect, and basically struck down the order. Not only that, but the parties involved in this particular judicial review, who included the National Electrical Contractors of Ireland, the Labour Court, the Minister for Business, Enterprise and Innovation, Ireland, and the Attorney General, they all agreed that the High Court judge would be able to make a decision or a determination about the validity and the constitutionality of the Industrial Relations Amendment Act 2015. 2015. He basically held that this Part 3, which gave the Minister the right to bring in these orders, was unconstitutional and struck it down. That means that the other sectoral employment orders in place in the construction and mechanical engineering industries, they're out the window as well. They're quite frankly invalid, and the reason is because the sole and exclusive power of making laws in the state is vested in the Oireachtas, and no other legislative authority has power to make laws for the state. That is set out in the Constitution. Now, the Minister might have some delegated powers, but if the Minister is going to have delegated powers, she must or he must be given fairly clear direction from the lawmakers in the Oireachtas. And the High Court in this case held that the Chapter 3 of the particular Act must fall, because the latitude and the discretion that was afforded to the minister was so wide that it was in fact unconstitutional. So, to sum up, the Industrial Relations Amendment Act 2015, Chapter 3, gives the minister the right, or did give the minister, or purported to give the minister the right to hand down these employment orders, sectoral employment orders. The judge in the High Court has now struck that down and held that it's invalid and unconstitutional, that piece of that Act, the piece of the Industrial Relations Amendment Act 2015, Chapter 3, that one. That means sectoral employment orders are out the window. Now, there was criticism then in the Dáil by TD, a Labour TD, or People Before Profit, I think, TD Breed Smith, and she's come in for a lot of criticism because she apparently made a lot of personalised remarks against the particular judge who made the decision. And she's been criticised widely for doing so. And this gives rise to the question of the separation of powers. In Ireland, there is a separation of powers provided for in the Constitution. And you basically have the judiciary, you have the executive, which is the government, and you have the Oireachtas, which makes the law, basically. And our system is such that the legislature, which is essentially the Oireachtas, the executive and the judiciary, are supposed to be entirely separate. And the question of a member of the Dáil attacking in a personalised way a member of the judiciary is unacceptable, according to many people. And one of the bulwarks, one of the fundamentals of any democracy is a separation of powers between the government, the judiciary, the police, and the lawmakers. And it is absolutely vital that each of these arms of state, as it were, are allowed to get on with doing their job, their important work, without being put under duress or unduly criticised or influenced by members of any of the other arms of state. There's no doubt about it that any judge can make a decision that's open to scrutiny and open to criticism. You can attack the law, however, but attacking a judge in a personalised way is, quite frankly, unacceptable. And the bottom line is, in any fair game, you should be playing the ball, not the man. And in this case, I think the TD in question has overstepped the mark from the sanctuary and the comfort of the privilege, the absolute privilege that she enjoys as a member of Dáil Éireann, because she made the remarks in Dáil Éireann. Anyway, that is the employment sectoral employment order situation. That is the striking down of that particular chapter of the Industrial Relations Amendment Act of 2015, and that is a decision of the High Court, which, as I say, has come under a personalised attack from a TD, which is unfortunate, to put it mildly, because it is vitally important that the judiciary, for example, are able to carry out their functions without fear or favour and without coming under pressure from various sources to make decisions in a particular ideological way. The judiciary, remember, are there to interpret the laws which the lawmakers have made, and the lawmakers, remember, can bring in any laws that they like, but they do, or they are entitled to bring in the law, but once they do, then the separation of powers situation provided for in the Constitution means that the legislature brings in the law and the judiciary interprets it, and obviously the police, the Garda Síochána, enforces it, and so on and so forth. But it's important that there is a separation of powers. It's important that that separation of powers is maintained. Hope you find this video useful. If you do, give it a thumbs up down below.